We believe that this is full of errors and legally unsustainable conclusions. But make no mistake, generally, all your attempts to create a chilling effect, a throttling effect, a strangulating effect on open, fearless speech relating to public interest will not stop either Rahul Gandhi or the Congress party. This particular speech was made in the context of price rise and unemployment, as the speech transcript shows. It was made in Kollar more than 3-4 years ago. And there are some disturbing aspects of this judgment which of course shall be subject to challenge proximately and immediately, but which I want to share with you very briefly. Firstly, the heart of the law of defamation, criminal defamation, is that persons who are complainants should be those who must be able to demonstrate how they personally, A, B or C, is defamed. How is he or she prejudiced? Now the admitted position is that no one which is the subject matter of the statement which is found to be offending has filed a criminal complaint. The first condition precedent of the law of defamation appears to have been patently not fulfilled and yet led to a conviction. Secondly, it is equally well established that malice is an essential ingredient of such offences. The very context of this speech shows that there could not have been any malicious intent. A leader of the political party of India with a pan-India footprint was speaking about unemployment, price rise, in the course of which there is a sentence which has been found to be offending, less than a sentence. The focus of the speech was not these three persons. The intent of the speech was not these three persons. The thrust of the substance of the core of his speech was not these three persons. In less than half a sentence on a speech about public interest, political issues in the country, major economic issues like unemployment and price rise, social issues, there cannot be any possible malicious intent, which is again another vital condition precedent to make out the criminal defamation. And that is patently missing. Thirdly, friends, it appears, and I think we are right more or less, but again we will check up and revert to you, that after this complaint was filed, and the magistrate who was at that time one Mr. X took up the matter, a large chunk of the time of the last 2-3 years was taken up by the complainant himself in going to a higher court and getting a stay of the entire proceedings, which is rather unusual for a complainant who should be interested in expedition. The same complainant, after a long period of time where he himself stayed his own complaint, suddenly withdrew the complaint, apparently after the magistrate, in respect of whom, before whom the matter had initially come, had ceased to hold office, and a different magistrate had taken office. It is that second person, Y, who appears to have passed this order.